Let's bring in our guest in studio, national trial attorney, Michael Jaafar. This, listening to him, it sounds like they are, whenever a defense attorney says, well, it's his constitutional right to have a trial, a speedy trial, it means, ruh-roh, we're in trouble, and DNA underneath the victim's fingernail, tough to get around.
That attorney looked like he was a little bit kind of putting a wedge between him and the strategy that's coming forward, right? It looks like he was putting a wedge, and there's no other way of describing it. Look, no criminal defense attorney is a stranger to a client steering the ship. Obviously, they're the person in charge, not the attorney. The attorney can give advice. What I read from his body language is that he may not want his client to testify, or maybe not. I was trying to parse his words, but at the end of the day, if you really step back and think about it, right, it kind of makes sense for Tellis to testify, because Tellis had yesterday a former partner of his in the real estate, business say, that looked like Tellis, I called Crime Stoppers. There's so much evidence that pointing to Tellis. I feel like it might make sense for Tellis to testify, but it's fraught with peril. The domestic violence background, there's a lot of things that could come out on cross that would hurt Tellis, but at the end of the day, there's an embarrassment of riches of evidence against them anyway. I feel like it's a Hail Mary. He might have to do it anyway.
Yeah, just because he's going down, it seems. And this guy's a well-known attorney in Vegas. He's gonna, at this, he doesn't want people at the end of the day to think, oh man, he represented Robert Tellis because he thought he was innocent. He was clearly saying, as a seasoned veteran, I represent people because they deserve representation, no matter how bad it is.
Yeah, and oh, by the way, I was only retained for the trial. He represented himself. Yeah. I mean, that was a little bit bizarre, but I do agree with him, right? Robert Tellis does have the right to a trial, to a jury, to confront all the evidence. It was just a little bit puzzling. I'm happy that Robert Tellis actually came to his senses and retained counsel. That guy's a good lawyer, and he cross-examined that real estate partner yesterday brilliantly. So he's got that tiger in him, and Tellis really needs it. I'll see whether or not the tiger comes out for the balance of the case, but the evidence against Tellis is so damn tough to overcome for a defense attorney.
Yeah, it sure is, and it's not just the DNA underneath the victim's fingernails. There's a mountain of it. It's cut up shoe. His behavior, erratic behavior. Let's hear some sound from a neighbor after the stabbing took place.
Once I turned the corner, I could see across.
Okay, but did you walk over to that other side?
I walked over to the other side.
And what did you see there?
When I made the right turn, I walked about another 6 feet or so and saw Sorry.
It's okay. Do you need any water? Or?
I saw Jeff.
You saw Jeff. Was he on the ground?
Yes, he was.
Okay.
And what happened next?
And then she came running in the house sobbing and screaming. And I said, what's going on? What happened? And I ran out there to my husband, and he was on the phone with 911. And he was in shock, and I went into shock. And he was having a hard time.
Your husband was?
Getting to the 911 operator to understand him.
Jeff Gehrman, not only a investigative reporter in Las Vegas at the Journal-Review, but it seemed like he really made an impression on people because the reaction to his death was, extensive and overwhelming. People really respected this man and were shocked and horrified by his death. That's a part of the equation, is it not, Michael, when presenting this case? Another bit of ammunition, if you will, a sympathetic victim to this jury in terms of the state's case.
It's very, very, listen, I've been in Las Vegas twice in the past 10 years, I've heard of Jeff German before this case, right? Jeff German was, a pillar in his community. He's known. Think about it. When there was a dissent in the office of Robert Tellis, right, public administrator, who'd they go to? Who did staff go to cry foul? Jeff German, right? So, another problem for Robert Tellis in this case is just the overwhelming amount of sympathy for the jury. Basically, people have just come into this case assuming Robert Tellis is guilty and said, look at the loss. This is more of like, some of these witnesses are more of like sentencing witnesses, right? That I've been watching this case. Like, these are kind of a little bit more, some of the testimonies, sentencing testimonies. So, I mean, Robert Tellis is cooked, man. He's got a challenge.
The defense in the opening said, Jeff German was great, and he would go up against some very powerful and crooked people in Sin City. I mean, he was an investigative reporter in a very tough town because there is so much activity, legal and illegal, and money and power. And they argue, hey, this guy had a target, and it wasn't just this city councilman who went after him. He was hit by a big boy.
The opening statement for the defense attorney for Robert Tellis was 40 minutes. 25 minutes of it were the defense attorney Draskovich talking about how many people hated Jeff German, right? And so that tells you what they're going to do, right? They can tell you that, hey, listen, Jeff German was a firebrand. People wanted him dead. Many people wanted him dead. Not my client. There were so many people who wanted him dead. 25 minutes of the 40-minute opening statement was just devoted to how many people hated Jeff German. Right? And obviously, I believe it. And any investigative reporter is going to be hated when they were exposing local corruption. Right? Corruption's more local than it is national, right? So that doesn't shock me. But that means there's so many people. You're a hero to so many people, right? So that's part of the rub with this case and with the defense.
Yeah, there's a lot of bashing of the media lately, but Jeff German is one of those guys that we need around as a society. Yeah. That it's invaluable to have real investigative journalism alive and well. So let's do this. Let's get a break. We're hearing there's a question in the Susan Lorincz case in Florida, so we are going to head to Florida, see what the jury has to say. They've only been at it an hour, and they already have a question. Interesting. You remember during the trial, it was established that the defendant's door frame had been broken and it was repaired, but it was still, I guess, weak, is what both parties sort of agreed to. She had a deadbolt bolt, but there was some damage to that door frame, and now the jury wanted clarification on how did that happen in the first place. Probably someone thinking maybe the victim was the person responsible for the door frame's condition. Michael Jaafar, what do you make from that question?
The first question I asked myself when I was looking at this case was that exact question about the door and the damage. Why? It's everything. Everything is cleaving to the same analysis that I had early on about this case, which is they're trying to see what a reasonably prudent person been in fear for their life if they were in your position, right? That's why they want to listen to the 911 call. That's why they want to look at the damage to the door. That's why they're trying to recreate the crime scene so they can make a decision. They know that they have this woman's life in their hands. She's 60 years old. If she gets convicted, she's pretty much going to jail for the rest of her life, effectively, right? What the sentence comes down to. They want to know, would a reasonably prudent person have been in fear for their life or just been annoyed? If they would have been annoyed, or if they would have just been afraid that you would have broken down the door and yelled at them, you did the wrong thing by squeezing the trigger. But if a reasonably prudent person would have been in fear that you would have killed them, then you did the right thing under Florida law. And that's why they're trying to recreate the crime scene. That's all they're doing.
Their first question was they wanted to listen to the 911 call. She made three or two. One was segmented. One before and then one after the shooting. The before one was the kids, and then after the shooting, and she was hysterical. And now the door frame. So yeah, if it was established that someone had beaten down her door at some point, and that's what caused the damage, yeah, that's a big deal. So the jury's looking for that little extra.
Yeah, then you were justified because, listen, if let's just say A.J. Owens was not banging on the door. Let's just say she was using a baseball bat and she broke through the door. Would we be here? Of course not, right? But that's not what happened. She was using her hands. So they're trying to recreate the crime scene. They want to see, what would I have felt if I was in your position? Would I have squeezed the trigger, or would I have just went into another room? That's pretty much what they're doing.
We got to hit a break. One word answer. If you're hear the defense attorney. Are you pleased with these questions or nervous?
Very happy.
All right. Let's get a break here. When we come back, we're going to head back to the Shanna Gardner case. Jose Baez representing Shanna Gardner.
Joining me in studio this hour, national trial attorney Michael Jaafar. Michael, I don't think it's surprising, 2 hours, 23 minutes in, 2 questions the jury had asked. They wanted to listen to those 911 calls. They wanted to know how the door was damaged. I think they looked at all the details. And what do you think of their verdict?
I think their verdict was proper. I think this jury did their homework. When they came back with those questions, I knew that what they were trying to do. They wanted to recreate the scene of the crime, but not just the scene of the crime, what a reasonably prudent person would believe at the time if they were in the same situation as her. The only way they could do it, the only way they could dig into her state of mind was to look at anything that was close to the scene of the incident. The 911 call, interrogations after, the calls before, all important, but not anything compared to the damage to the door and to the 911 calls after. Why is it important? Because you want to know what would a reasonably prudent person have felt, not done, felt at the time. Because under Florida law, you cannot use deadly force unless you have an imminent fear that someone is going to use deadly force against you, right? You can use regular force, not deadly force. Deadly force is reserved in Florida only if you feel that you are an imminent threat for deadly force. So how would the jury know this? They have to look at her 911 calls and the damage to the door. I'm sure if A.J. Owens was trying to break that door down with a battering ram, they would have came back different. But she had her hands and she was knocking on the door and she got shot. In Florida, you can't do it. She was still outside of her domicile, outside of her house in the castle doctrine. So I think the jury did the right job and they did their homework. They didn't come back in 10 minutes and say guilty.
Right.
You know?
Right. They looked at it again. They made sure. They decided. It was a jury of 6. We know that's an option in the state of Florida. This was 6 individuals, unanimous decision. You know, and I just want to go through quickly the manslaughter definition in the state of Georgia. An intentional act, they determined it was, in Florida, that was neither excusable, which it was not, nor justified, and that it resulted in death. So they found it was not justified, it was not excusable. Now I want to juxtapose that with really quickly listening to this defendant, now convicted of first-degree manslaughter, but to this defendant telling the police during her interrogation that, hey, I feared for my life. Let's listen together.
I really feared for my life. I mean, honest to God, I was like, I'm a nervous wreck. You know, I'm not supposed to be getting nervous or anything like this because I have an aneurysm on my left kidney artery. And so they're like, just, you're supposed to stay calm, you're not supposed to do anything. And this woman just keeps attacking. I said, wait 10 minutes. She's got the kids calling me. I haven't talked to her to agree. Do not talk to me like I am one of your peers.
All right, so there we heard her saying she feared for her life. But I guess, Michael, the jury must not have believed her on that video. She didn't testify. They did see that interrogation video. They must not have believed what she was saying.
One of the jurors must have said, hey, listen, she has had a bunch of self-serving statements after the fact. I don't think a juror would have believed that she opened up Chapter 776 of the Florida Penal Code and researched, you know, what justification would have happened. But I know that the debate in that jury room would have centered around whether or not she feared for her life or whether a reasonably prudent person would have feared for her life. We know that her defense attorneys brought in evidence that, you know, her friend was raped and bound and all these things, right? They wanted to recreate in the jury's mind, hey, this person would have thought something different than somebody else. Also, her door had previously been broken down. They did a fantastic job.
They did.
Yeah, they did a fantastic job. This is another, I don't know what's going on in the state of Florida, Judge Jesse. They're turning out cases that are going to be taught in law schools. This is a case that a law professor would have to teach his kids because it could have really gone either way. If the jury would have came back and acquitted her, I wouldn't have been surprised.
I agree with you. It could have gone either way. And again, it was her state of mind. Would a reasonable person have been in fear for their life? Let's listen also to the description of Owens, the victim in this case, who is unfortunately deceased as a result of this gunshot wound, and what was said about her trying to get inside of that door the defendant shot through.
So AJ, she came to your door.
Oh, yeah.
And she was
pounding on it. Like, I was like, what the hell? My cat's going to fling it.
What was she saying? Was she saying anything?
You don't talk to my sons. I'm going to kill you. I'm going to kill you. I'm like, oh, you know, and I was like in tears. I'm like shaking, and I'm like, oh my God. And I thought she had gone away, and then she starts banging again. I'm like, oh.
Did she, like, try to come inside?
She was trying as hard as she could.
And what do you mean?
That door was moving. And I'm like, holy, you know.
Like, did she try the door handle, or was she just beating on it to try to push it in, or what?
She was just, you know, just trying to push it in, trying to push it in. And I was like, oh my God.
So what was she saying again?
She's like, you can't talk to my sons that way. You know, I'm like, you're trespassing, you know.
So you were communicating with her through the door?
Yeah, I'm like, all right, just leave. You know, I don't want to hear it. Now I'm going to kill you. I'm going to kill you. And I didn't think too much of it until she really started pounding that door. And I'm like, oh my God. Then I got scared, like terrified, scared.
Pounding on the door, terrified, scared. Again, the jury did not believe her at the end of the day, but rather believed that she intentionally shot through the door, and it was not excusable. It was not justified. How does it feel when you're representing someone standing there? She's facing up to 30 years.
Yeah.
That is a lot of life, arguably the rest of her life.
Yeah.
How does that feel waiting on that verdict?
This is the most jarring moment. I mean, even when I was a public defender and I'd have, you know, 10 clients a day, right? And when we would try 3-4 cases a week, even as something as small as a misdemeanor, right? Even on bench trials, you would it was nerve-wracking. That's a difficult place to be for any defense attorney and any defendant. Any defendant that ever sat next to me was trembling when the jury came. And then they were trembling. This is the most anxious moments. And honestly, Judge Ashton, when I see these videos, I feel like I know I'm looking ahead, but I don't think this woman's going to get sentenced to the max. I mean, this case was so close. It was so down the middle that I feel like she had a convincing case to be afraid. I think she went over the line, shooting a gun through the door. But at the end of the day, you know, the jury, they were there, they saw it, and they did their homework. They didn't come back in 10 minutes. They did their homework. I liked it. I trust their wisdom on this case.
Yeah, and I agree with you. They did their homework. I just have to mention that without the firearm, she would have had second-degree manslaughter facing 15 years. That firearm makes it a first-degree felony and faces 30 years. So maybe she gets closer to 15 years. We don't know what's going to happen at sentencing. But to your point, we're going to have to wait and see on that. All right, it looks like they're still at that sidebar. I want to bring back in National Trial Attorney Michael Jaafar. Michael, I was asking you, because you were a public defender, defense attorney, is it common for police to do this? These shenanigans where you're talking to a witness and acting like you're lying, you're not telling this to the truth. Well, we wanted to arrest you, but I'm trying to convince them not to. Is this typical?
100%. It reminds me of a meeting I had with a federal, with the U.S. attorney, with a client, where the U.S. attorney came in and said, listen, I'm going to tell you something. He was talking to my client. All these investigators in the room, they're allowed to lie to you. They're allowed to manipulate you. They're allowed to say whatever they want to get any information from you. I'm an attorney. I'm not allowed to do it. So I'm going to tell you the truth. It's typical. It's exactly how the profession works. I'm not saying I agree or disagree with it, but that is exactly how it works. It's completely typical. They're competitive people, just like anybody else in that career, and they have difficult jobs. So they do whatever they can to elicit, and a lot of them make a decision and a determination by looking at a person. You've done it. I just got to figure out how. It's very typical. It's sad, but it's typical, and that's the way it happens.
And they're allowed to do it so long as they do not violate the constitutional rights, of course, of the individual. All right, I believe the sidebar is over. Let's go back inside court. So, Michael, I want to ask you about this attorney. Jose Baez. If you're an attorney, you know his name. We know Harvey Weinstein is one that he represented, Aaron Hernandez, Casey Anthony. Many have heard of the mother, Casey Anthony. So, you know, he's an excellent attorney, and you can't blame him for going back to court to say, you need to give her bond in this case, Judge, so she can get out of jail. Do you think he'll be successful?
I think he will be successful. This is very typical. I'll tell you why. Defense attorneys, all attorneys are very competitive, and the best thing you can do is win. It's better than getting a fee. You have to win, and to win, you need things to help you win a case. What helps you win a case more than evidence, or as much as evidence? Having a client, a defendant, be at home to help you prepare for the trial. It's very difficult to prepare for a defense when your client is behind bars. It stinks, it's smelly, it's difficult. Every move is listened to. You have to take a day, you have to give them notice, you have to sit in the lobby. As a busy attorney, if I have 10 clients at home, 1 client in prison, it's easier for me to prepare for those 10 cases than that 1 case. And you have the possibility that your client will be dumb and get stir crazy in jail and make a confession via email, make a confession to her friend. You know, it's so much better to have a client at home. So this motion is overdue. It's good. He's got good evidence. I think he'll be successful. But he has to try, and having a client at home to prepare for a trial is worth it. It's almost as good as DNA evidence, not as good as DNA evidence, but it's almost as good as DNA evidence.
It gives you the ability to prepare the way you need to prepare for a criminal trial at the end of the day. All right, I think now those technical difficulties have been resolved. Let's try again. Still joining us for this hour, National Trial Attorney Michael Jaafar. Here's what I heard, Michael, when he asked about the DNA evidence found under the fingernails of the victim, and the response was, it will be a difficult cross. He has the right to a fair and impartial jury. He deserves his day in court. To me, that makes it sound like they just don't have much of a defense.
That, to me, looked like a wedge. The attorney's creating a wedge between him and the potential eventual loss. I think he knows he's going to lose this case. That's a big guess by me, because they haven't even put on their case yet, but I felt like that was a wedge. For him to say, you know, he hired us for the trial, it kind of bothered me a little bit. But, hey, listen, Robert Tellis is a politician. Politicians can't stop talking. They just want everybody to hear him talk. So I think he's going to just continue to talk and talk and talk. And I think he's going to take the stand. I think he's going to open the door to a lot of very uncomfortable evidence that his attorneys will have to contend with. And it's going to be difficult. This is going to be a very entertaining remaining set of, you know, evidence that comes in. I'm really looking forward to seeing Robert Tellis get up there. I want to see how he's going to explain the DNA, how he's going to explain the hat. Is he going to say that the police planted it? They took my DNA and they put it under Jeff German's fingernails? Are they going to, they cut up the hat, the straw hat that the framed person wore to make the murder? They took it, they cut it up, they put it under my bed. It's going to be very, very jarring. But hey, it's theater. We're going to see what happens.
You know, Mike, I feel like, and I don't know if you've ever been in this position, but both the defense attorney and the defendant are both what I think is damage control time. They know that this case is going to an inevitable conclusion. And I think those comments that you talked about from the defense attorney saying, look, I just came on this case for trial. He was his own attorney up until just a little while ago. I think that's about damage control for his own reputation. And I think it's the same thing for Tellis. He made the point that Tellis has insisted from the very beginning that he wants to take the stand, tell his story. He knows he's done for. I think he wants to take the stand and protect his reputation as best he can, as he knows he's probably going to spend the rest of his life in prison.
Completely agree. That's exactly what it is. That defense attorney he said exactly what he needed to say in order to protect his reputation. He's going to have another client next week, next month, next year. He's a younger person. He's going to have many clients who are going to ask him. They're going to gauge his strategy with whatever case they're looking at. They're going to say, well, you had Robert Tellis take the stand and he embarrassed himself, because he has a taste of what his customer is going to say. His customer is going to get on the stand and get on his soapbox and say things that I think the defense attorney knows are going to be incriminating. By the way, this defense attorney, in his cross-examination of the prosecution witnesses, especially that real estate agent, masterful. So he clearly knows what he's doing. He clearly is comfortable in a courtroom setting. He's clearly good at thinking on his feet, and he just completely eviscerated that real estate agent. So I know he's got talent, core talent, experience. And we're going to see what happens when they put on their case on Monday.
Yeah, he's a high-profile attorney, absolutely a good attorney. I agree with you, Mike. But at the end of the day, what we all have to remember is that most of the time defense attorneys lose.
Yeah.
You know what I mean? They win, right? The prosecution wins over 95% of the time.
You're
They won't
right.
admit to it.
So
You're right.
most of the time we lose. So you go in and you do the best you can. You try to protect the Constitution, the rights of the defendant, and you take what you get.
Yeah, you're absolutely right. And, you know, I do appreciate that he even said that to the public. He is entitled to a fair and impartial jury, a presumption of innocence, all those bedrocks of our judicial system, or our criminal justice system, I should say. All right, let's bring in National Trial Attorney Michael Jaafar. It can be confusing, pre-trial motions, getting all that straight as to what's for what. So, Michael, in listening to this, what do you think a remedy would be that's appropriate for the court to do if you take her testimony as the truth?
I mean, if the judge believes in her testimony, the remedy is to throw the text messages out, right? Because at the end of the day, they've been screaming from the rafters, the defense team, that these were hyperbole, right? Before this motion hearing, Jose Baez was saying these are just hyperbole, these were jokes. And I told the detective that. And this is not the first time that this detective has been told that he was not prepared, right? There was many instances on the record in prior hearings where this detective just was not prepared for this case, and he's the lead detective on a capital case. So to be honest with you, this is why we have these motions in the jurisprudence system, is for a reason. Throwing evidence out is inconvenient, especially when you know that the evidence is important. It's inconvenient, but this is why we have these options, because sometimes we have to use them. And whenever we use them, somebody who might have done something nefarious gets away with the nefarious thing that they did. So the remedy would be to throw them out. But this is, again, why we have these options in the justice system, is because sometimes we have to use them, and when we use them, they're inconvenient. So to me, that's a potential remedy. Other than that, I'm sure there's some other form of remedy, but that would be the remedy I would look at.
Could it be another bond hearing, Michael?
No. I think what ends up happening here is the judge allows it in, Mike. I think he does that because I don't think this was something that was done on purpose, right? Because that's one of the things they look at. And ultimately, let both sides testify, let the jury decide. You know, let the jury decide whether they believe that these are really jokes, right? You listen to Kim Jensen, you listen to the detective, and you figure out, that way. I think that's the best and fairest way. So when I look at her testimony, though, I think about her in the context of the trial. And I think this type of testimony is, I think, very helpful for the defense. If they call her at trial and she gives this testimony, gives us a real sense of who Shanna Gardner is. She was part of church, part of this group, seemed like a good person, struggling with a tough relationship with a guy who didn't really seem like the nicest guy in the world.
Yeah, she has a track record of not attracting people that are really on her team. If these text messages are introduced, obviously they'd have to bring in Kim Jensen, and Kim Jensen would have to come in there and testify and say these were jokes, these were hyperbole. Again, there's too many coincidences for the defense in this case. If these text messages are brought in and she's joking about a hitman, and there was a hitman, and Henry Tennant actually is testifying that he was hired as a hitman, I feel like this would be the case for the defense. Definitely for Mario. I mean, if these text messages were brought in, I know that these messages were between, Shanna and her friend, but I mean, the walls would be closing in. And hey, maybe if these text messages are brought in, and maybe if all of this stuff keeps going the way it is, maybe we'll see Mario and Shannon start, crossing paths, and one taking a plea to testify against the other. We don't know.
It hadn't happened yet. I'm a little surprised.
I'm anticipating that might exactly happen. But let's not forget, just as another point, the judge has already thrown out information in this case, communications that the state looked at that were actually attorney-client privilege.
Yes,
so there's a
from the
record
jail.
of kind of from the jail. So it's possible that she could throw them out. So
But not only that, the prosecution is denying that they didn't provide them. The prosecution says, no, we did give that information to the defense. So there's also that dispute between the two sides. All right, we need to squeeze in a break. Thanks to Michael Jaafar for joining us.
Absolutely.